Good morning. My name is Daryl Krause. I'm an attorney here at Bauman Law. I wanted to take a moment to talk to you about your upcoming mediation. Mediation is a procedure where the two parties discuss their dispute with the assistance of a trained, new, impartial third party, a mediator, with the goal of reaching a settlement to the disagreement. It's typically an informal meeting, and right now it's being done by Zoom. Your case is suitable for mediation, and we have decided to go that route. And ultimately, the decision is yours as to whether or not to accept the mediation proposal. The mediator has no power to force you to accept the proposal, because ultimately you are the one who will need to determine whether or not the amount of the mediation settlement is agreeable to you. However, the expertise of the mediator is very beneficial in coming up with a framework for that agreement. And there are numerous reasons why you might choose mediation over going all the way to trial. One is affordability, because every day that your attorney is working towards trial and during trial, you will incur expenses along the way that will ultimately come out of any amount that you are awarded. Additionally, the time required to resolve your dispute is much sooner with a mediation than a trial. Getting into the courtroom, as you can imagine right now, is very difficult. The schedule is backlogged for a year or more. Also, there's confidentiality when you are engaged in mediation, whereas if it's in trial, it's open court, anyone can see it. And ultimately, the resolution that you come up with can be very tailored to your specific case. And it can really achieve a win-win situation. And ultimately, if you're winning, that's a good thing. How it works? Well, normally there's a mutually agreed upon place that's neutral for all of the parties to meet. Right now, that's over Zoom. And who will be there will be myself or your attorney from Bauman Law, and you from the defense will be the defendant, their attorney, typically also an insurance representative, and the mediator. Now, it won't be a situation where you and the defendant will be speaking directly to each other, necessarily even in front of each other. We will be separated into different breakout rooms, with the defense in one and us in another, and the mediator will go back and forth between the two rooms. If you and I, or you and your attorney, need to speak privately, another breakout room can be created that we can be placed in, and then we can have any private conversations that we need, so that we can be advised along the way as to the reasonableness of their offer, or strategize how you want to proceed. Most importantly is that the defense is required to have someone there who has the authority to settle the case, if possible. So there's several stages to the mediation. The first is an introduction. The mediator will give an opening statement and description of their training and experience. Will ensure that there's no ethical conflicts between themselves and anyone else. And once all of that is done, there will be an agreement to mediate. If it's not already been signed, will be signed there. Confidentiality of the proceedings will be explained, and also if there's any disagreement or later there the parties want to have attorneys review that mediation, they can stipulate to that. There will be an opportunity for breaks and lunch if needed. You're encouraged to be very courteous and allow, if the mediator chooses to allow you and the defendant to speak directly to each other, not typically, but if they do, then you are encouraged to be very courteous, to allow that person to make their statements without interrupting them, and they will be encouraged to do the same for you. You can take all the notes you want. Make sure that if you have any questions that come up, write them down. Let us know along the way. If you need to take a break, all you have to do is say so. If you need to speak with us privately, all you have to do is say so. There will be times when the mediator will go into the other room with the defendant and they will be discussing their side of things. The mediator will point out the strengths and weaknesses to the defendant for their case, as well as the mediator will point out the strengths and weaknesses of your case to you. But all conversations between the two parties and the mediator are confidential. The mediator will not tell them anything that we've discussed, and the mediator will not tell us anything that they've discussed with the other side. If there is something that the mediator wants to disclose to both parties, they will ask permission to do that. And that can really, truly move the case forward in surprising ways. The mediator will ask you to basically tell your side of the story, and we will also be filing a mediation brief beforehand so that we can bring the mediator up to speed on the facts of the basic facts of the case, the law around the case, and what we see as the strengths and weaknesses of the case. Understand, if you don't settle the dispute at the end of the mediation, there's no penalty for that. And you can still go forward with the case at the end of the day if it's not an acceptable mediation agreement. The only thing that has to be reported to the court is that there was an unsuccessful mediation. That's all. Now you may be asking, who is this mediator that's going to be essentially the judge of sorts for your case? Most mediators have a good number of hours of training. They have experience, either as an observer or co-mediator with someone more experienced. They are typically a judge, a former judge, or an attorney for many, many years, and they've chosen to pursue this part of their career to help people resolve their differences. Although a law degree isn't required, if someone is not an attorney, then there are more stringent experience and requirements. Now, what about the ethics of the mediator? There are statutes that have established what the ethical requirements of a mediator are, how much training they must have, as well as the standards that are adopted by the American Arbitration Association, the Society for Professionals in Dispute Resolution, and like I said at the beginning, the mediator will ask if there are any conflicts. We'll make sure that there are no conflicts between themselves and any of the parties or attorneys involved, and if there are, they will excuse themselves. So I hope this helps you understand what's going to happen during your mediation. Remember, it's important to be there on time, and be there the whole time so that we can work best to try to resolve your case. You should receive connection information from our office prior to the meeting. If for some reason you have not received that information, please contact us and let us know so we can get you that information. It's important that you be able to show up without distractions or interruptions. If you have a desktop or laptop computer that you can use in a different room than, say, the living room of your house or apartment, that would be best. If you have small children, please try to arrange for daycare or someone to take care of them while you're at the mediation, because we want you to be able to focus on your case. This is a really good opportunity to try to get it resolved without waiting for another year or two to get into trial. And at trial, you can't control anything. Ultimately, it's going to be the decision of a set of jurors. Here, you can control the outcome. Might not be the perfect outcome, but it is one that you can control. And you have the ultimate decision authority for that framework of the resolution. And lastly, we appreciate you being a client of Baumann Law. And if you have any questions, please call us and let us know. Thank you.